รวมความรู้ด้านนิติศาสตร์สร้างภูมิคุ้มกันภัยด้วยกฎหมายใกล้ตัวกับรายการจุฬานิติมิติโดยคณะนิติศาสตร์จุฬาลงกรณ์มหาวิทยาลัย
Good morning, ladies and gentlemen. You are listening to LaฬChula NitiMiti, a radio program aiming to promote the expression of legal perspectives from our instructors at the Faculty of Law, Chulalongkorn University, each with their own expertise in different areas of law.
LawChula NitiMiti airs every Sunday from 11:05 to 11:30 in the morning via Chula Radio Plus, the official radio station of Chulalongkorn University, FM 101.5 MHz. You are now with me, Jinjutha Charadsooksawad, a freshman from Thai program at the Faculty of Law, Chulalongkorn University.
And me, Pawarisa Tangsutjaritwong, a sophomore year student from LBO program, which is an international program at the Faculty of Law, Chulalongkorn University. Both of us will be the host for today's program. Today's episode is very special as it is our first English episode of LaฬChula NitiMiti.
Today, we'll bring you another captivating legal topic to talk about, which is comparing comparative law perspectives on Thailand. We are honored by Asst.Prof.Dr.Surutchada Reekie, an instructor from the Faculty of Law, Chulalongkorn University, who will be our special guest today to educate us on this issue. Good morning, Professor.
Good morning. Thank you for having me.
Before we begin, can you tell us a little bit about yourself and your research interest?
Certainly. My name is Surutchada Reekie. I am a full-time lecturer at the Faculty of Law, Chulalongkorn University. I received my LLB, LLM, and PhD from University College London or UCL in England, and I also received an LLB in Thai law from the LLB graduate course or Pak Bandit from the Faculty of Law, Chulalongkorn University. My main research interests lie in comparative private law and trust law.
I heard that you recently published a paper in comparative law in an international journal. Can you please tell me about your inspiration in writing this paper?
Of course, the main inspiration of my co-author and I was to present comparative law perspectives from Thailand to the world. We think because of the language barrier, many excellent comparative law works from Thailand have not yet reached the global audience. So we were inspired to write about great works of leading Thai comparative law scholars and tell the wider global audience about their perspectives in comparative law. And I think this is the focus of this session.
Could you please tell us about the focus of this session?
Okay, so this session is to talk about my recent paper on comparative law, which I co-authored with Assistant Professor Adam Reekie from Thammasat Law School, and it was published in April 2024 in the International and Comparative Law Quarterly, which is a highly regarded law journal. It is ranked top 10 on the subject of law by Saimego Journal Rankings, and it was ranked Q1 on Scopus.
With all these statistics and ranking, could you please elaborate more on what does this mean?
So generally speaking, Saimego and Scopus are international research databases that rank journals based on various criteria such as impact, prestige, and citations, which means that these academic databases recognize the International and Comparative Law Quarterly as one of their top journals in the field of law in the world. So getting published in ICLQ is a very difficult thing to do, and I was honored to be published there.
Well, congratulations on your achievement.
Thank you.
Could you please clarify more? What is the paper about?
Our paper is about three leading Thai scholars, Professor Bridi Gasemsap, Professor Pishais Approach, and Professor Snankorn Sotipan.
Why is it important to write about these three professors?
Because these three professors are top Thai legal scholars, but they published most of their works in Thai language, and therefore they are not well known outside Thailand internationally. But the quality of their work is truly world class. So we want to introduce their works to wider international readership because we believe that their works are a great contribution to the field of comparative law.
That is very interesting. The next question I would like to ask is whether comparative law is just about comparing legal rules from different countries.
Not really, although that is part of the discipline. Comparing legal rules from different countries is sometimes known as functionality approach. And this terminology was first coined by two German jurists called Konrad Zweigert and Heinz Kurz in their book entitled Introduction to Comparative Law, which was first published in German language in 1987. However, there is a lot more to comparative law than just one approach.
Can you please elaborate more on the approach on comparative law?
Okay, let me say this first, that the discipline of comparative law is relatively young. It's only just over 100 years old. And academics often attribute the formal starting point of the discipline to the first International Congress of Comparative Law in Paris in the year 1900. But it is a fast-growing field and has its own theories and jurisprudence, just like other fields of law, such as corporate law, constitutional law, or criminal law. Comparative law academics are normally interested in the approaches of comparisons and the theories or conception underpinning the comparison.
Why is it important?
Because my co-author and I would like to add the voices of comparative law from Thailand, and not just as a case study to Western-centric theories, but we would like to present comparative law discourse from Thailand as a truly significant contribution to the underpinning theoretical discussion of comparative law. You can see this as a part of a wider movement, I think, in the fields of social science and humanity, sometimes known as Orientalism, which I guess simply put is the movement of scholarship away from Western-centric discourse and more towards the emphasis on localism and local voices.
Turning back to the content of your paper, I would like to ask what is the main approach or research methodology?
In brief, our main comparative law approach was that we researched into the body of works of each academic, of each professor, and then we identified aspects of their works that are related to the field of comparative law. This meant that we read through all of their works that we could find, and then we identified the aspects of comparative law, and then we analyzed their comparative law discourse, any distinct discourse, and explained and evaluate their works in the way that we hope would bridge the understanding of comparative law voices from Thailand to the existing and prevailing discourse in the field.
What are the notable aspects of their works that you discussed in the paper?
Okay, perhaps there would be no time to go into the detail of every point we make on the paper. Anyone who's interested to learn more may go into any of the academic database and look up our paper, which is entitled Comparing Comparative Law Perspectives from Thailand, published in the International and Comparative Law Quarterly, abbreviation ICLQ, volume 73, April 2024, page 447 to 475. But just for today, maybe I can talk about one or two interesting aspects of the points that we made in the paper. Let's start with the works of Professor Bridi Gasemsap. Regarding the works of Professor Bridi Gasemsap, we focused on his three-layer theory of law or three-tier theory of law, which is known in Thai language as ทฤษฎีกฎหมายสามชั้น. We identified this as a hallmark of the Thammasat school of legal thought and also an important cornerstone of modern Thai jurisprudence.
Can you please explain in brief what the three-tier theory of law is about?
Okay, Professor Bridi Gasemsap described or sought to explain the foundational concept of law through its evolution across three stages. So in the first stage, which he termed people's law, the law originates from customs, morality, and reasons which already exist in a particular community. The foundation of law is therefore simple natural reason of that community, which was developed later into law through the expediency of repeated and widespread use by its member. So this type of law does not require a sovereign in the sense of legal positivism, but reflects the Latin motto ubi societas ibi jus, which is where there is society, there is law. And the second stage of legal development is what he termed lawyer's law, which represent laws developed by the legal world of judges and lawyers through judgments and legal reasoning, and also legal doctrines developed by legal scholars. So in this second stage, the people's law is refined, conceptualized, and systematized for application to the demands of more complex communities. The law, therefore, is no longer aligning with simple natural truth in the community, but represents the legal methods and legal reasoning of legal professionals. Then we come to the third stage, in which Professor Bridi Gasemsap termed legislated or technical law. Technical law then represents legislation which is derived from legislative process, and this does not necessarily have to align with long-standing customary practices, but is devised by the deliberation of human will and design through the country's legislative process.
What are the implications of this theory to comparative law discourse?
Okay, we think that technical law by Professor Bridi Gasemsap was very interesting to the field of comparative law for two main reasons. First is because it is an expansion, we think, of Carl von Savigny's conception of law, which Professor Bridi, we believe, expanded into the field of technical law, whereas Savigny, I think he saw law more as a spirit of the people, which was developed through customs and popular consciousness, and not through the imposition of by deliberate legislation. And Professor used this conception of the three-tier theory of law to explain the interaction of Thai law and foreign laws during the reform period of Siam in the late 19th century to the early 20th century. And we gleaned this from his paper on reception of law in Thailand, entitled Reception of Law in Thailand, a Buddhist Society, which was published in a book entitled Asian Indigenous Law in Interaction with Received Law, published in 1986. So in this paper, in this book chapter, he talked about the difficulties in the process of reception of Western legislated technical law during the reform period when Siam was using traditional law, which was a combination of people's law and lawyer's law, to use his own terminology. And this created some sort of state of incongruity which later caused many problems to Thai legal system. And he said, and I quote, "The Western positivistic jurisprudence was hurriedly imparted to the East. The spirit of jus strictum was fortified by an overconfidence in the omnipotence of law. Therefore, we argued that he was ahead of his time in challenging the assumption of superiority of modern Western-inspired law over traditional law in Siam, and this is in line with the contemporary direction of comparative law research, which has gradually moved away from Western-centric discourse towards localism. This means that the starting point of comparison should no longer has to be Western jurisdictions. And this is what this movement away from Western-centric approach is about. When Western jurisdictions were once thought of as classic comparators, this contemporary legal comparatives, instead they say that the starting point or the comparators that are non-Westerns are equally valid to be chosen as comparator. And comparators can be chosen from outside Western jurisdictions.
That's very interesting for Professor Preeti Kasemsap. Should we discuss more about Professor Pishais' idea?
Idea in comparative law is very interesting, and I am honored to say that I was his student and I was in one of his last classes before he sadly passed away. In our paper, we discussed his body of comparative law work, which revolved around his distinct economic-led approach to comparative law. His approach to comparative law is non-Western centric and is sympathetic to the needs of developing countries such as Thailand. And we think that this is a new approach or new voice or a new idea that has not been discussed elsewhere in the comparative law discourse. And he proposed that the primary utility of legal comparison was to enable one jurisdiction to select an appropriate legal approach to adopt or apply in our own legal system, which he called happy plagiarism. And in order to do this, he proposed an economic-led approach to comparative law in two steps. The first is to select donor countries with legal solutions that would most suit the economic and social settings of the recipient country, and then choose the most appropriate legal solution based on its efficiency in terms of its ease of reception and ease of application in the recipient country. And these two considerations should not be thought of as consecutive steps, but instead as two strains of analysis that should be conducted in harmony in order to serve the primary utility of comparative law, that is the efficient development of the country's law. And in the first step, he emphasized on the comparators which are at least one step more advanced in the economic sector that the area of law that we are interested in belongs to, so that the recipient country may aspire to achieve the same level of economic advancement by adopting the legal solution from the donor country that will push the country towards that desired stage of development. And therefore, his approach or his methodology to comparative law is particularly useful for Thailand and countries of similar developmental states, with an emphasis that the solutions should take the path of least resistance. So this is something that comparative law literature from the West does not really talk about. And we think that, therefore, he offered something that is distinctive and very valuable to the existing comparative law theoretical discourse.
Overall, what have you learned from writing this paper?
From many years of researching and writing this paper, I think it took us about 4 years from the inception of ideas to publication. We have learned that Thailand has a lot to contribute to legal discourse at international level, and that we no longer have to think of our jurisdiction as a case study to legal theories that are proposed in the West, but instead we can see ourselves as one contributor to theoretical discussion on an equal footing to bigger jurisdictions or jurisdictions that are usually thought of as the classic starting point of comparison. In fact, I think Southeast Asia in general is an interesting area for comparative legal studies. And this was recognized by many leading scholars from around the world. For example, Professor Andrew Harding, who is a leading scholar on Asian laws, who has taught at leading institutions such as Oxford, and the School of Oriental and African Studies in London, and the University of Victoria in Canada, and the National University of Singapore. Professor Andrew Harding compared Asian legal landscape to the multi-layered tectonic plates, which means that there are very interesting complexities to legal landscapes in Southeast Asia that are worth researching into.
So before we say goodbye, any final thoughts from you?
Okay, my final thought is this. I think in the past, we scholars always look to the West for ideas or answers. But researching for this paper taught me that Thailand has many world-class academics and law academics as well, with world-class quality of work. So our main problem in the field of law and comparative law is communication, because most of the works about Thailand are published in Thai language still, and are published within Thailand. So we should try to bridge the understanding of Thailand and the world, and we should publish more in English language in order to communicate with the world. And this is what I have been trying to do.
That's very insightful. We have gained valuable insights and knowledge from today's discussion. We would like to thank Professor Surutchada Reekie for the knowledge shared with us today. For those of you who want to listen to our previous episodes, they are available at www.law.chula.ac.th or in YouTube channel LawChula Channel and podcast Chula Radio Plus.
For next week, we will bring you yet another legal issue with our special guest. Rest assured they will be interesting as always. We will see you again at LawChula NitiMiti, airing every Sunday from 11:05 to 11:30 in the morning, via Chula Radio Plus, the official radio station of Chulalongkorn University, FM 101.5 MHz. For today, all three of us would like to thank you for listening. สวัสดีค่ะ
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 กลับมาติดตามสาระความรู้และเรื่องราวที่น่าสนใจของวงการกฎหมายกับรายการจุฬานิติมิติโดยคณะนิติศาสตร์จุฬาลงกรณ์มหาวิทยาลัยทุกวันอาทิตย์ 11:00 น.ทาง Chula Radio Plus FM 101.5 MHz